The United States District Court for the Southern District of Iowa is now in session. The Honorable James E. Gritzner presiding.
Take a seat, please. Good afternoon.
Good afternoon, Your Honor.
Your Honor. We are convened in the matter of West Liberty Foods versus Moroni Feed Company, number 10-146, on the plaintiff's motion to vacate in part and confirm in part the arbitration award, the defendant's motion to enforce judgment settlement for confirmation of the arbitration award, and the notice of fraud. This matter will be video recorded, and the video may be posted on the website for the federal court system and this court's website. The parties to the case have agreed to allow cameras operated by the court to record the proceedings, so please limit noise, side conversations, and other disturbances, and we have already limited the router that was driving us all crazy, so hopefully it'll be a little bit quieter. I would anticipate, given the posture of the pleadings, that it would be appropriate to hear from both sides twice. So I'll start with West Liberty Foods, and we'll just go back and forth a couple times so that you both have an opportunity to respond to one another. Mr. Tank?
Thank you, Your Honor. Can I remain seated?
Can he be picked up by the camera if he remains seated?
Yeah.
Okay, yes.
Thank you, Judge. May it please the court, we're back. We were here
back.
Several years ago, and we've come back after some effort to resolve our differences pursuant to your order. We have filed a motion to vacate, a motion to confirm, and a resistance to a motion to certify, and also have brought to the court's attention a matter that we feel may bear on the court's ruling, that namely the notice of fraud that we have filed. Although the case and the posture in this matter is a bit complex, it is our view that there are two essential questions that the court should consider and address in ruling on the various motions. The first question is simply whether the award that was entered by the arbitration panel qualifies as a reasoned award as to the prejudgment interest included in the final award amounting to $2.1 million. The second issue that we think is ripe for the court to consider is the significance, if any, to the court of the affidavit that had previously been filed from Attorney Johnson that we believe the record now demonstrates was a false affidavit. On the motion for partial vacation, I'll start with that on the reasoned award issue, if that's so. Arbitrators have virtually unfettered authority, and the court's mindful of that, and so is the plaintiff here, West Liberty Foods. We understand that when we enter into an agreement that submits something to arbitration, if in fact that's what our agreement did, but if we were to arbitrate that dispute, we give up certain rights that we would have in court. Everyone knows that, and I am mindful that in order to persuade the court to vacate part of the award here is a burden, and it would be unusual, I think it's fair to say, for the court to enter such an order. Having said that, I think it bears mention that the powers of an arbitration panel are governed by the parties to the arbitration. In other words, it is the parties' agreement that enables the panel to do its work. It is authority from the parties that is given to the panel. And the panel must operate within the specific authority that has been given them by the agreement. In this case, the panel was required, pursuant to the contract, it's not really in dispute here, they were required to enter what is known as a reasoned award. In other words, they had to provide the parties some explanation as to the outcome of the arbitration. Under the Federal Arbitration Act, this court can conclude that if the panel did not comply within its authority, in other words, if it entered an award that was not a reasoned award, that would be in excess of their powers. They would have done something they were not authorized to do, and the court, based on that finding, could vacate the award. So the question really is, what does that mean? What is the requirement for a reasoned award? And there are not many cases that I was able to find, Your Honor, that really put a lot of meat on that bone. But I did find a pretty clear consensus that a reasoned award is something short of findings of fact and conclusions of law. Doesn't have to be that, but more than a simple result. So it's got to be something. It cannot be nothing. The mission, I think, is to review the four corners of the award. It was labeled an interim award, but that constitutes the logic and the findings that were made by the panel, to find or discern whether in that document there was an adequate explanation for the substantial prejudgment interest award that was made by the panel.
You're answering one of my questions, I think, but let me be sure, and that is that in determining whether or not it was a reasoned award, I can look at the entire document.
Yes.
Rather than simply the section that deals with prejudgment interest.
Yeah, well, if you can find discern a basis, yes, you can.
Yeah, and then the next question is, must it be an express explanation, or can the explanation be gleaned from the remainder of the document without an express statement to that effect, but it's a deduction that is obvious from the document?
I think it can be inferred. The question is whether the language in the award allows the court to make that inference. And our position, both before the panel and here, is that the issue of whether prejudgment interest was appropriate is based on a different factual standard, and in fact a different legal standard than applied to any of the issues that were addressed in the award. So again, we raise the issue, we say it's not there. That's the challenge to Moroni. Point to it, explain why the court should either make a finding that it's there or that would enable the court to reasonably infer that based on what the panel said, they did, in fact, decide the issue of prejudgment interest. And as to, I don't think so far we're really far afield with Moroni on the law. It's got to be a reasoned award, and it's got to be something more than nothing. The arguments that Moroni makes in support of this prejudgment interest are really twofold. The first one is to argue that, you know what, this prejudgment interest issue was such a utterly trumped up issue, and the panel really was not obligated to deal with it at all. And the court can infer from their failure to address it that they just ignored it. Moroni says, I don't want to misquote him, and I'll quote him directly. Obviously, The failure of a panel to address an argument that is without any basis under the relevant law cannot give rise to an argument that the panel's decision was not reasoned. They go on to say, West Liberty Foods' legal argument against Moroni's prejudgment interest award was so utterly without legal basis that it did not merit any discussion in the award. Well, we think that there is a robust issue on the entitlement to prejudgment interest. The parties identified the issue in their submissions to the panel, separate, independent of the other issues, and the parties briefed the issue of prejudgment interest separately and independently of the other issues. So it was not a throwaway argument that didn't need to be assessed. It was a real bona fide dispute between the parties that required some comment. The second argument is where the court's question leads us, which is, if the panel said enough about something other than prejudgment interest that would adequately support the prejudgment interest award, isn't that a reasoned award? Can't the court construe it as they've said enough? They didn't identify, there's not a subsection in the opinion, there's not a specific discussion about it, but they said enough in their award that the court, before you endorse this award, can feel confident that it was a reasoned award for prejudgment interest. And the argument that Moroni makes in support of that position is the following. Prejudgment interest is justified based on the panel's finding that West Liberty Food breached its contract with MFC. I think that's a proper argument. In other words, if the court were to conclude that the facts and the law necessary to support an award of prejudgment interest are the same facts and the same law that supported a finding of a breach of contract, the court could reasonably conclude that the panel in fact addressed the issue, even though they didn't speak of it particularly. The problem with that is based on the fact that this issue of prejudgment interest was not based on the same evidence and involved a different legal standard than would enable the panel to find a breach of contract. And I know we're not here to persuade you that the Utah law doesn't allow prejudgment interest, but in order to determine whether you can infer from a finding of breach of contract, there's enough there to conclude that under Utah law, interest is the normal incident or naturally and automatically flows. We've addressed Utah law in our briefs.
You have, the examples that you cite seem to be, for lack of a better term, more egregious than the situation that we have here, and that there were some very large and significant gaps in the record available in those cases. What is missing here to enable, under the Utah standard for prejudgment interest, what is missing in this record to reach that conclusion?
Based on the Utah law?
Yes.
In order to award prejudgment interest under the Utah statute, the court would have had to have made a finding that the damages here were established with the requirement that would enable the court to say that
I think the standard is that the damages were ascertainable and mathematically calculable, as I read the Utah law.
It was unclear to me reading the Utah cases exactly what the standard was. You're right, of
But
course, John.
you can see what's missing in those cases. It's pretty clear. And so my question is, to make sure I'm comparing apples to apples here, what is missing here in order to reach the conclusion?
In the award, what could they have said?
Yes.
Oh, well, here's what they should have done in my...
What did they not have in order to make the decision?
Well, they had enough. I mean, the evidence was presented to them. I don't mean the weight of the evidence supported the award, but there was enough information in the record that they could make that decision. And the Utah cases that talk about compensatory awards on the one hand and prejudgment interest on the other draw a clear contrast. And like Iowa, they say that in order to sustain a compensatory damage award, damages must only be established with reasonable certainty, or there must be some reasonable basis, rather, on which the record would support the damages. It's more forgiving. What the panel should have done is to address specifically the related but separate question in this case of whether the evidence was of such a quality in this record to sustain the prejudgment interest. And so the cases that I've cited from Utah all draw this contrast. Canyon County Country Store versus Bracey. While the basis of the formula used to determine plaintiff's lost profits may have been sufficient for the jury to render a verdict in favor of the plaintiff, it is too speculative to allow for the addition of prejudgment interest. Price-Oram versus Rollins. Although the evidence is sufficient to support the damage award, it is far too uncertain to support a prejudgment interest award. So clearly there's a line, there is a heightened level of proof that is required before prejudgment interest is appropriate. And this panel said not a thing about that.
It sounded to me earlier that you were telling me that there was a record there from which this conclusion might be made. You might disagree with the conclusion, but that there was a record there for the conclusion to be made. They just didn't do it in the fashion that you think they should have?
No,
is that correct, or have I misunderstood?
I don't know what they didn't do anything on prejudgment interest. The evidence was submitted to them, and arguments were made both as to the quality of the proof on the issue of compensatory damages, breach of contract, and also whether the quality of the proof was sufficient to meet this higher burden of reasonable mathematical certainty, or whatever the standard you can discern from the cases would be. And it was our argument, quite zealously, that if the standard is met for compensatory damages, there's no way that this sort of formula that was conceived and applied by their expert Erickson could possibly meet the standard necessary for prejudgment interest. Because what Mr. Erickson did was highly subjective. This is our argument. I mean, they could have disagreed with us. Judge, here's what they could have done. They could have analyzed the case and said there was a breach of contract based on the four corners. It was an unambiguous contract. You know what? We don't like that. We lost on that. I'm here unarmed to qualify or to argue about that. So I got to live with that. They also found that Mr. Erickson's opinions were sufficient to support this compensatory award that we thought was just, grossly inflated. We lost on that one too. And I'm stuck with that. What they didn't do was to then analyze the next step, which is, having found that there was a rational basis for the damage award, we now consider whether the evidence on damages meets the heightened standard required for an award of prejudgment interest. And on that issue, they said nothing. And so if the standards were the same, in other words, if the evidence, if the evidentiary standard was the same and the legal standard was the same, you could infer that, well, they didn't say it, but they sort of did say it. If you look hard enough at that award, you can really reasonably conclude that they thought about it and it's the same thing. It's the same test. Some of the cases that analyze whether an award is reasoned do that. I think the Catt case that we discussed at our briefing ultimately concluded that, well, the panel or the arbitrator didn't go through, chapter and verse on all 5 or 6 claims, but in that case, the outcome was driven by a common nucleus of facts and a common finding. I think it went to credibility. So it's there. It may not be labeled correctly, but it's clear that the panel or the arbitrator considered the issue based on the correct standard. There's nothing in this record that would give West Liberty what it was entitled to, which is, we're going to give you authority, panel, and you can drop a brick on us for compensatory awards. They wanted fees and expenses, they wanted punitive damages, and they wanted prejudgment interest. And we subjected ourselves to that possibility when we were in front of that panel. What we were entitled to in return was some basis, some statement in that award that ensured that they acted within the scope of their authority, which required a reasoned award. So they owed us that. And they had to give us something. And it may not have been extraordinarily, it need not be extraordinarily detailed. Perhaps they could have just put a paragraph in that award and said, we recognize that the standard for prejudgment interest is higher based on this case, and we have assessed the evidence in light of that standard and find that the heightened standard of mathematical, I don't think it's mathematical certainty like it is in Iowa, and we also are satisfied that that standard has been reached, so we're going to drop another $2 million on West Liberty. They didn't do that.
I think the thrust of my question goes to the fact that, first of all, if we're talking about the Utah law, I think the concept is it has to be from the record, it has to be ascertainable and mathematically calculable. And so that means that there's got to be something in the record from which you can reach this decision. And then, given the deference that I must necessarily give to arbitration, the decision might even be wrong in my eyes. but I still have to accept that. And so the question then becomes, if in fact the record contained the information from which they could reach this conclusion, if they had simply said so, is the fact that they did not say so enough to overcome the deference that I'm supposed to show?
Yes. That's our argument, Your Honor, and that's precisely what we're saying. If the panel had analyzed the issue and offered reasoning in support of it, the prejudgment interest, we wouldn't have an argument. I mean, they were asked to do that. And if they applied the law and they got it wrong, we'd be without a remedy. But they didn't. And you are being asked now to adopt this, and you are entitled and obligated to assess whether the award that you have been asked to enter as a judgment over your name meets the contractual requirements that were imposed on the panel. I mean, we had 3 judges, and judges have inherent authority. Arbitrators don't. They don't have inherent authority. Their authority is limited to the contract. In our argument, I'm getting a little redundant, but they had to do something to meet their contractual obligations. And to the extent they did something that was outside of their contractual duty, it is in excess of their authority, and can be vacated. So that's my argument on the prejudgment interest partial vacation. I can address the other issue.
Yeah, why don't you go ahead and let's do that too now.
All right. Our position on, we're kind of on both sides of this issue. In other words, we're asking affirmative relief, which is that the court vacate the award because it is not a reasoned award as to the interest. And we're also resisting the request that Moroni has made to certify the award. So we're on both sides of that argument. And as to our resistance to the request to certify, we have three basic arguments. First, the one I've made, that you cannot certify this award because there's not a reasoned basis for the prejudgment interest. The second argument that you can consider is whether Moroni has met their statutory burden for certification, which requires them to demonstrate that a valid arbitration agreement existed between the parties. And the third basis that we suggest the court can consider in determining whether to certify the award is what significance the court assigns to the affidavit that we claim was false. The defendant, Moroni, doesn't seem to dispute that it is their burden to show an enforceable agreement to arbitrate. They simply contend that you've decided that, and you did. Back when we were debating the motion to compel arbitration, we came to you and we gave you an affidavit, and it was our argument to you at that time that the arbitration paragraph in the contract did not survive termination because it was not included in the survival paragraph that enumerated specific paragraphs, not including the arbitration paragraph. And we argued that the contract clearly read as such, and we also argued that you should invoke the doctrine that says an ambiguous contract will be construed against its drafter in the event you found that part of the agreement to be ambiguous. And our evidence of that was an affidavit that stated clearly and definitively that Mr. Waters, who was representing West Liberty, received a proposed agreement with an arbitration clause that was either clear or unclear that had been drafted by counsel for Moroni Feed. And that paragraph, even though there were back and forth discussions, that paragraph was never changed. And so we argued that it's clear that it doesn't survive, but if it's not clear, construe it against Moroni because they drafted it. And in response to that, we receive an affidavit that is basically the opposite. It is from Mr. Stephen Johnson, and he told you in his affidavit that he did not represent Moroni Feed while preparing the marketing agreement and related documents. And that puts you in a difficult position, Judge, because you can't assess credibility of an affidavit, and you had to make your decision based on the record. And at the hearing, Mr. Preston argued quite clearly that this doctrine of construing against Moroni doesn't apply here because Moroni did not draft that provision, and he said the following. And so, he, referring to Mr. Johnson, was not representing Moroni Feed's interest, and he specifically asserts that, affirms that in his affidavit. So to argue, as West Liberty had, that this contract was drafted by Moroni Feed is simply not correct. And we've cited other excerpts in the transcript that are to the same effect. Based on that record, you were unable to apply the doctrine that a ambiguous paragraph is construed against its drafter because you couldn't tell who the drafter was based on these conflicting affidavits. But what you did say, in your opinion, was...
Well, I guess I could tell who the drafter was. I couldn't tell whether it was Moroni.
Correct.
Yeah.
Yeah, we knew who drafted it. The individual, Mr. Johnson drafted it. Whether he was representing Moroni, that was the question. And so you did this analysis, in your opinion, and you went through it correctly. You looked at the agreement, and you said, well, do I have to invoke anything? Or can I just read it and apply my common sense to what it says? And as to that, you said, the marketing agreement is ambiguous when attempting to determine the party's intent regarding post-termination survival of the arbitration clause. So you found it to be ambiguous, and you concluded, or you elected rather, to rely on another, I don't know if it's a tool of construction, but it's a doctrine that says if there's ambiguity, the court may resolve issues in favor of arbitration. And that's the law, and you elected to base your decision on an ambiguous contract based on this preference in favor of arbitration, which you had, you were within your discretion to do that. But you also said a couple of things in the ruling that indicated to West Liberty that you, at least in part, relied upon the false statements in Mr. Johnson's affidavit. You said as follows: the record indicates that the marketing agreement was drafted by counsel for Norbest, Inc. You also say the attorney for Norbest drafted the agreement, arguably in the interests of Norbest, but did not represent Moroni as Moroni was represented separately. And then you said the following: on this record, the court declines to apply the doctrine of contra proferentum to this case. So you found that based on the evidence in front of you at the time, you were not going to invoke that doctrine because the record would not support the argument that we were making that the contract was drafted by Moroni. Well, we found out a little less than a year ago that the affidavit upon which you relied, in part, in reaching your conclusion was false. And we've cited to the somewhat inscrutable deposition of Mr. Johnson in support of that fact. But we asked him directly several times, you were representing Moroni Feed, and he on several occasions said yes. And if there was any doubt about that, it is put to rest based on the fact that in the course of examining Mr. Johnson, certain objections were made as to privilege. And one of the privilege objections that was made was relying on the fact that Mr. Johnson represented Moroni Feed. So we've cited a case. We think there's an estoppel here to deny that Mr. Johnson represented Moroni based on the invocation of a privilege. In other words, if you claim attorney-client privilege, you can't later deny that there was an attorney-client relationship. Mr. Preston will get up and say, well, I also objected based on an attorney-client relationship he had with Norbest. And that is true. But he clearly Well, I was concerned about it, because when I heard it, I knew it was contrary to the affidavit, and when I heard the attorney-client privilege invoked, I requested clarification. And after the instruction not to answer, I made the following record. And the attorney-client relationship that is the basis for this instruction is between Mr. Johnson and Moroni Feed Company, correct? Mr. Johnson answered, it would be between me and Moroni, and me and Norbest, and me and Nebraska, another related entity. And I said in response, well, your counsel has to explain to me, so I understand the objection, which privilege he feels protects that. And Mr. Preston said, well, I agree with Mr. Johnson's characterization. So we have an affirmative claim, invocation, in the course of this arbitration that is directly contrary to the unequivocal statement made to you in support of the motion to compel arbitration. So that's your call, Your Honor. In other words, if you believe that your order was reliant on the false statement as it is suggested to be, I think you have the inherent authority as a judge to do something about that. And that's your call. I read your opinion, I can't read your mind. I know what you said in your opinion. Whether that affidavit...
Well, there's nothing else left in my mind.
Well, you know, you're going to have to answer the question of, did the affidavit affect your ruling? And if it did, then you have to decide whether you want to do anything about it.
So your legal basis for raising the issue is the court's inherent power to react to what the court regards as fraud on the court.
Correct, yes. I mean,
You're not proceeding under Rule 60.
No, I'm not, clearly. And you know, this is an interlock. Remember, at the end of the hearing, you asked me directly, should I stay this case or should I dismiss it? And I said dismiss it. And you said, well, your order, you went back and you analyzed it, and there's a good body of discussion in your opinion, and you concluded that under the Eighth Circuit standard, the better course was to stay it. And the effect of that is that the ruling that you made to compel arbitration is interlocutory. There was never a final ruling. And you have discretion at any time before a final ruling to change an interlocutory decision. So there's no final judgment. I don't think the rule on final judgments applies based on your decision to stay rather than to dismiss. But more significantly, and this is where I come at it in a little bit of a different, from a different perspective. You may elect not to change that ruling or not to really do anything in light of your perception of what happened and whether you relied on it. You could conclude that that's ancient history, you're not going to mess with that. But in order to certify the award, at this stage, you have to revisit the issue on the burden of Moroni to demonstrate that there is an enforceable arbitration agreement that will justify your signature on a judgment. So you have to revisit that issue now, and I would say normally something like this would be a perfunctory exercise. You say, well, I read the contract before and I found it to require arbitration, and I read the same contract now and I reach the same conclusion. So even though you technically revisit it, you're basically you're reaching the same conclusion. I think in this case, and under this record, the situation is quite different. And now you can look at this agreement that you found to be ambiguous and base a decision not on the false affidavit of Mr. Johnson, but on the affidavit of Mr. Waters, which clearly and unequivocally said the arbitration paragraph that was found to be ambiguous was drafted by Moroni. And if you conclude that based on this record, you cannot certify because a showing has not been made sufficient to earn your imprimatur on this award. So, you know, I read 100 cases on arbitration, and I've read 100 times that you may not like it, you may think it is wrong, you may think it is irrational, unreasonable, whatever. You have no authority generally to do anything other than enter it. And that's the world we live in under the Federal Arbitration Act. And all that is true. You do, however, have the authority to hold the panel to its contractual responsibility, namely that it not enter an award that isn't reasoned, and if they are presented with an independent claim based on a different factual requirement and based on a different standard in law, they can't ignore that issue and then at the end announce the result. You don't have to approve that. The parties to the contract are entitled to have the panel do what the panel authorized them to do. So you don't have to stamp that. And as far as the assessment of the agreement and whether it is a valid arbitration agreement, you have to revisit that now under the record that is clearly more favorable to Moroni, whether it meets your, you know, whether you, if you go back and look at it, whether you would have reached a different, or whether you would elect to reach a different conclusion now is something you have to puzzle through, but it's clearly a better record for us than it was at the time of the motion to compel arbitration. And let me just, my final thing goes back to one of the issues you raised, and I want to be very clear on this. The argument that you can see in this award a basis for the interest award, it's not there. It is not there. There has been no assessment by this panel of the evidence sufficient to support a $2 million award of prejudgment interest. The only thing, and they did talk about the quality of the damage evidence. They spoke about it. And they said as follows, and this is all they said. The damages calculated by Erickson were supported by the evidence, reasonable, and justified. That's it. And if prejudgment interest can flow or is supported by evidence of damages that is only reasonable, supported, and justified, you can find in that award enough language to enter or endorse the prejudgment interest award. If you do not, however, there's nothing else in that award that would support it. You can read the Erickson report is in the record. I mean, you can read it. You know, it doesn't support an award for prejudgment interest. It's a extremely complicated analysis that was highly debated, and in fact, any argument that it was just math and was a liquidated claim is refuted by the fact that the panel asked Mr. Erickson to do some additional fine-tuning on his numbers before they awarded that number as the compensatory damage. So, you know, the standard in Utah is not so unlike the standard here in Iowa, which is you have to meet a higher burden for prejudgment interest than you do for compensatory damages. So thank you so much for your attention, Your Honor, and that concludes my initial argument.
All right, thank you, counsel. Mr. Brisson?
Thank you, Your Honor. I'd prefer to be at the podium if that's okay.
That's fine.
Your Honor, may it please the Court and Mr. Tank, opposing counsel. My name is Stan Preston. I have with me Tom Johnson from the Bradshaw Fowler firm as local counsel, and Ross Blackham, who is the general counsel of Moroni Feed Company. Your Honor, I would like to start with the legal context in which the Court is required to resolve these issues that are before the Court. And that is a context that is highly, of course, deferential to an arbitration panel. And we've cited a lot of that case law, but just it's very clear. Courts use phrases such as any review is exceedingly deferential, judicial review is extraordinarily narrow, courts must exercise great caution when setting aside an arbitration award, severely restricted by statute, and that a party bears a very heavy burden in seeking to vacate an arbitration award. I submit that that burden is heavier when you are trying to set aside an arbitration award on the basis that the award is not reasoned. As the Fifth Circuit has stated, based on the well-established deference afforded arbitration, courts have generally been reluctant to vacate awards for failure to render a reasoned award. And there are many courts across the country, and we cite several, who say that is not a basis under the law. So that's the context in which we deal with that. I think the standard, we've cited some cases that say when you're dealing with whether a damage award is reasoned, that is even a higher standard. So let me focus for a moment on what is a reasoned award. The standard is very low. It must simply contain or mention some explanation or justification for the award. My primary argument, and I disagree with Mr. Tank's characterization of what our position is, my primary argument is that the award is reasoned. It's a 21-page award written by 3 very competent judges. They addressed all 8 of Moroni Feed's claims. They addressed each of the counterclaims in detail. They explained the method for the calculation of damages for each. And I submit that the panel's statement of the award of prejudgment interest meets this extremely low standard as to what constitutes a reasoned award. It's important that we recognize we're dealing here not with a case of future profits or a projection of profits. We are dealing here with historical transactions. It is possible, and it is established by our expert, you can calculate to the penny exactly the amount of accrual funds that West Liberty Foods generated and used. It is also based on the voluminous accounting records that are available. You can go through and look at the facts and calculate to the penny the amount of accrual funds that were generated from the sale of my client's products as opposed to Nebraska turkey growers' products. This is not a case like the cases which Mr. Tank has cited where there is conflicting expert evidence as to how the calculation should be done. There is no conflicting testimony on this issue. Your Honor, I think if we looked at 5 cases, they will illustrate why this is a reasoned award in its entirety, and that's how courts look at it. As Mr. Tank has admitted, courts look at the entire award to see whether one portion is reasoned on those courts that allow you to look at that. The 5 cases are Cat Charter, the Carmody decision, the Leeward decision, the Rain C2 Chlorine LLC case, and then the Vold case. Let me start with the Cat Charter case. Both sides cite this case. In that case, the award only provided, there were a number of claims and counterclaims, and the panel said as to two of the claims that the plaintiff has proved his case by the greater weight of the evidence. That is the only explanation they offered. That's it. Then they denied all the other claims without explanation and denied all the counterclaims without explanation. Now, they sustained the claim on a misrepresentation under Florida statute, and they sustained it as to a breach of contract. There were breach of fiduciary duty claims. Now, clearly, credibility was a major issue, but when you're dealing with breach of fiduciary duty, you would expect a reasoned award as to say whether there was a duty, how the duty arose, or if there wasn't a duty, or how it was breached. There's no discussion of any of that. Now, much of that award is cited in the case, but I have also pulled the actual award, Your Honor. And I would like to provide the court with a copy of that, if that's okay. This is pulled from PACER, and I'll provide it, of course, to counsel. May I approach the bench to do that?
You may. I'm not sure how much good it does me, but you could provide it to me.
I just want to...
All right.
Well, Your Honor, we've never seen this, and you're going to consider it for the weight you think is appropriate, but I just want the record to reflect that until this second, we have not been informed of this intent to give you this, even after they got here today. I've not seen this until just now.
It's outside the record, and I can assure you that it's not going to get much weight. I'll see what it's given to me to illustrate.
Well, this clearly shows that all they said was what I said, that it's by the greater weight of the evidence, the plaintiff proved his claim. And at the end of it, in paragraph 7, it says, it lists the total amount of damages and says with prejudgment interest accruing thereon at the statutory rate. Very similar.
To the extent that the court failed to recite all of the facts that you're interested in, I will get my facts from the court opinion.
Well, this was attached, of course, to the record that is in that case, Your Honor. But the point I want to make is that they looked at the entire record and they said those two sentences were sufficient. Now, in this case, what we have is you have a breach of contract that is fully established. You have two paragraphs explaining about the damages, summarizing the methodology, saying that you took the total amount of accrual funds, that they were able to determine which ones were from Moroni Feed, and this is all set out in Mr. Erickson's expert report. And then Mr. Erickson deducted certain accrual funds, as established by the records, that were rebates or that West Liberty Foods could have legitimately deducted under the contract. And that is on pages 9 and 10 of the award. There are certain offsets for freight issues or quality issues. And what I'll just submit to the court that the record showed that under the contract, West Liberty was supposed to raise those with Moroni Feed Company, and then they would determine whether that is something that should be offset. But what West Liberty did is they said, well, we'll just pay for part of it with the accrual funds. So in an effort to be conservative in the amount of damages, Mr. Erickson went through and determined what those offsets and rebates would have been. I believe that an argument, certainly what could have been made, and it was discussed at the hearing, that all accrual funds from our accounts were improper. But we gave them the benefit of the doubt. That's the only real judgment that was exercised there as to whether this fit into rebates or not. The court then said, and this is on page 21 in the conclusion, based upon the evidence and contracting law, I think they meant to say contract law, but it says and contracting law, the panel concludes. And then it has certain things, and one of those is the award of prejudgment. That phrase, I submit, is very similar to the phrase that was in the Cat Charter case that the court recognized. Gave sufficient for a reasoned award. That alone, it's based upon the evidence and contract law, that's a justification for the award of prejudgment interest. That is sufficient for a reasoned award. Now, let me also direct the court's attention to the Carmody case. That case is instructive because a party was challenging a lack of reasoning with respect to a single issue, and yet the court was determining whether to vacate the entire award for the alleged lack of reasoning as to that issue. Now, in that case, the parties agreed that 5 issues would be submitted to the panel, and the challenge was that there wasn't reasoning for one of those issues. And what the court said, petitioner's specific contention is that the arbitrator failed to issue a reasoned award with respect to issue number 3 because he did not address whether and to what extent the parties and the construction project were impacted by conditions that arose subsequent to the August agreement. Petitioner demands too much. A reasoned award requirement does not obligate the arbitrator to discuss every single piece of evidence or to show how every single proposition he adopted could be derived from first principles. And then the court looked at the entire award. Quote, given the award's length and detail, including its reference to exchanges between the parties that occurred subsequent to the August agreement, there is no doubt that the arbitrator rendered a reasoned award as bargained for by the parties. Let me refer the court to the Leeward decision, which again both parties cite. In Leeward, the arbitrator provided an award for, quote, change order work, close quote. And that was challenged by the other side, arguing that that award of compensation was not reasoned because the arbitrator, all he stated was that from the evidence presented at trial, the court finds that Leeward is entitled to such compensation. What the Leeward court said in response to that is that the decision in this case was well over 30 pages long with considerable detail regarding the panel's findings and conclusions as to the various components of the overall award. The parties had ample opportunity to contest Leeward's entitlement to compensation for change order work. And the summary nature of the discussion in the decision shows that the panel simply accepted Leeward's arguments on this particular point. While the award may have been deficient if it summarily indicated agreement with all of their arguments, that does not mean that the arbitrators were obliged to show how every single proposition they adopted derived from first principles. Again, that's exactly our case. This issue was argued as to prejudgment interest. The court found a breach of contract, found damages that were clearly calculable with mathematical accuracy, and then it found, based on the evidence and contract law, Moroni Feed was awarded prejudgment interest at a statutory rate, referencing a Utah statute that, according to case law, prejudgment interest can only be awarded under the appropriate test, which I will discuss in a moment. Then that's the fourth case, is the Rain case. Let me quote a section from that I think is highly relevant to this case. Quote, given the deference employed when evaluating arbitral awards, and as all doubts implicated by an award must be resolved in favor of arbitration, the award in this case is sufficient to withstand Conoco's request for a vacatur. Conoco's argument against the award hinges on the summary nature of the arbitrator's statement that based upon all the evidence, he found that the initial price formula should remain in effect. Conoco ignores that the preceding paragraph thoroughly delineates Rain's contention that Conoco had failed to show that the initial formula failed to yield market price, a contention that the arbitrator obviously accepted. So again, they're inferring from what's in the entire award that the arbitrator accepted the prevailing party's issue on these points. Conoco would have this court vacate the arbitration award merely because the arbitrator did not reiterate this reason in the following paragraph. Such a narrow approach is inconsistent with the deference owed to arbitral awards and the congressional policy favoring arbitration of commercial disputes. And it's also contrary to the issue of finality. The last case is the Vold decision. Vold is the only court in the history of the Federal Arbitration Act, as far as reported decisions, where a reasoned award, or where an award was vacated on the grounds that it was not reasoned. Now, in that case, the arbitrator simply itemized the various dollar amounts of each of the claims, but gave no reason for each award, no reason whatsoever, no reason for rejecting the other side's counterclaims, and the award did not mention any of the relevant contract provisions at issue, cite any law, or discuss any of the evidence admitted during the 4-day hearing. That case is entirely different from what we have here. Contract law provisions were mentioned, law was cited, evidence was discussed, and based on the evidence and based on contract law, the panel awarded prejudgment interest. What is particularly interesting about the Vold case, Your Honor, is that in that case, there was no dispute that the award was not reasoned. Both sides conceded that. The issue before the court, and this was the South Dakota Supreme Court, was whether the arbitrator had the right not to issue a reasoned award. And there was a very compelling dissent in that case where the dissenting justice indicated that to have a reasoned award under the AAA rules, you have to have a written agreement signed by both parties. That didn't exist here, so we can't vacate it. But the court implied that there was an agreement. That was the issue where they're dealing with. So that gives us no guidance as to whether this case, which is so different, should be vacated. And again, Your Honor, that is the only case where a judge has ever vacated, or a court has ever vacated, an award on the basis that it was not reasoned. Now, much of West Liberty's brief deals with this prejudgment interest and Utah law and what that is. And I would like to answer what I think the question the court was asking is what was missing here, what makes the Moroni Feed Arbitration Award similar to the cases that have been cited by Mr. Tank and West Liberty Foods. I submit that this whole argument is a red herring because it's based on an assertion that it's Moroni Feed's position that there is a strict contract-tort dichotomy and that you can never get prejudgment interest in tort cases, but you can always get it in contract cases. That is not what I said, and I cite the court to page 3 of our resistance memorandum where I said, West Liberty has failed to cite a single Utah case which would disallow prejudgment interest in this type of a breach of contract case where the damages are subject to mathematical calculation. Clearly you have breach of contract cases where prejudgment interest is not authorized because the damages are not subject to mathematical calculation. And I submit if you look at the Utah cases, the test is the following. The damages must be fixed at a definite point in time, and the loss may be measured by facts and figures, as some courts have stated, or be calculated with mathematical accuracy, as other courts have stated. That's a two-pronged test. I submit it was met in this case. Again, we're dealing with historical transactions, thousands of pages of documents documenting these transactions, but it was clearly fixed in time because each time there was a sale and accrual funds were generated and kept by West Liberty Foods, damage occurred. And you can calculate that, as Mr. Erickson did, on an annual basis, looking over the past year, what were the accrual funds that were kept. Are they subject to mathematical accuracy? As I said, they can be calculated to the penny, the amount of accrual funds. And then you can look at their accounts and see that some went to this store as a rebate, and again, it's an exact amount, and you simply deduct that amount. Is there some judgment as to whether that was it a rebate or not? Yes, there is some judgment there, but that doesn't render this entire calculation not subject to prejudgment interest, because you're relying on facts and figures, and it can be calculated with mathematical accuracy. And I think a key case that illustrates that is the Utah Supreme Court decision in ENCOR, E-N-C-O-R, or ENCON, I'm sorry, E-N-C-O-N, 210 Pacific 3rd, 263. Let me just quote something from there that I think is directly applicable to this case, and the argument that, well, the damages changed, and you know, the court asked Mr. Erickson to do an additional calculation, and then they deducted that from the damages. Again, he was able to calculate it to the penny. But this is what the court in ENCON said. The purpose of awarding prejudgment interest is to compensate a party for the depreciating value of the amount owed over time, and as a corollary to deter parties from intentionally withholding an amount that is liquidated and owing. A party can only be properly compensated for the value of the amount owed over time if the amount owed is subject to mathematical calculation. This does not require, however, that a party must demonstrate that its damage figures are known and static from the date the claim is filed through the final judgment. Were we to hold that damage figures could never change, we would foreclose the possibility of awarding prejudgment interest in nearly every case. And in that case, the Utah Supreme Court determined that a dispute, even between experts as to the precise amount of damages, did not preclude those damages from being measurable or calculated, or calculable, and that the lower court was not left to its best judgment to ascertain damages. And it said the court based its final decision on measurable facts and numbers. And that's exactly what you have here. And you need only look at Mr. Erickson's report to determine that. That is all in the record. That's why I state that this is not a sort of case that would ever be contested as prejudgment interest. And let me just illustrate that by three of the cases that they cite. They cite the BC Technical case. I'm very familiar with that case. I tried that case. There were damages sought. I was defending a company that repaired circuit boards, and the plaintiff was seeking $1.5 million in damages. And the jury awarded $140,000, as I recall, and the plaintiff wanted prejudgment interest. And the court recognized that there was conflicting evidence as to when the date of breach occurred. There was conflicting evidence as to the amount of circuit boards, as to whether the boards could be repaired, as to whether it would have impacted lost profits in any way, because there was conflicting evidence as to whether the plaintiff had enough circuit boards to meet its demand. And the court said it's speculative. You can't determine this with mathematical accuracy, what the damages are. It was left up to the jury to use their best judgment, so prejudgment interest was not allowed. The Cornea versus Wilcox case. This was a breach of contract claim regarding valuation of cattle, and there was competing expert opinions. And there was competing evidence as to the number of cattle, the pregnancy rate of cattle, the weight range of the cattle, looking forward into the future, the loss rates, the mortality rates, the market prices. Again, those aren't fixed at a point in time, and they're not subject to mathematical accuracy. You have experts who can opine on the compensatory damages, but again, that is not this case. Counsel mentioned the Canyon Country Store case. Again, there's no relevance to this case. That was a lost profits case, as are most of the cases that are being mentioned by counsel. Here, there was a loss and enough evidence to establish damages, but they were highly speculative lost profits to be earned by a business who had no operating history, had been in business for, I think it was 14 months, and it had never shown a profit. Clearly, that's a case where prejudgment interest will not be allowed. That is not this case when you're dealing with historical numbers that are verified by facts, by documents, and by the numbers in those documents. So, Your Honor, we submit that this was a case that was reasoned, and it can be inferred from the court's language and its findings, its adoption of Mr. Erickson's report, its adoption of his schedule where he calculated the prejudgment interest, and by the fact that they reference the Utah statutory 10% rate where the court has interpreted it that prejudgment interest rate only applies where the damages are fixed at a definite time, that they are relied upon by facts and numbers, or they can be calculated with reasonable accuracy. The recitation, the citation to that statutory rate shows that the panel made that conclusion. So it flows from their findings and their decisions. Your Honor, I wanted to just briefly mention, and this has been a point of contention within the briefing, we have contended that under the current Eighth Circuit law, that you cannot vacate in part. It's an all or nothing proposition. And if I could just explain briefly why I state that. Counsel says...
Rely on the Stark case at all in that regard?
Yeah, absolutely. And so this is our reasoning. The cases they cite were cases that were decided prior to Legion, the 1999 decision. And in Legion, what the court did is it said the following: Our review of the initial arbitration order convinces us that the arbitration panel intended the award of premiums to be indivisible from the award on the letters of credit. Whatever the rule may be, under different circumstances, when a panel, by language it uses, makes clear that it intends its award to be indivisible, that's the qualifier, the district court must take the award as it finds it and either vacate the entire award using Section 10 or modify the award using Section 11. Now, footnote 5 to that, if you look at it, it's very illuminating. It says, our precedents are somewhat unclear as to whether a district court may ever partially vacate an award using the standards of Section 10. It cites the Central Lab case where the Eighth Circuit approved it. That's a case that counsel cites. And then it cites the UHC Management Company case where the Eighth Circuit held Section 11 only applies when a litigant seeks to have part of an arbitration award nullified and part of the award confirmed. But then the court says this: because the arbitration panel was explicit in its intent to make an indivisible award, we need not decide all the components of this issue today. That's 1999. Fast forward 3 years to 2002, and the Schultz, Bob Schultz Motors versus Kawasaki Motors Corp. And again, I have not cited this case because it wasn't in, because I didn't have a chance to respond to the reply, but it's 334 F3rd 721. I'm sorry, that's 2003, so it's 4 years later. This is what the court said. In sum, congressionally mandated deference to arbitration proceedings means that, quote, a district court must take the award as it finds it and either vacate the entire award using Section 10 or modify the award using Section 11. Now, what is missing here? It's the qualifier on the indivisibility language. It just states it as a bright line rule at this point. It doesn't mention it or even recognize that language. The next year, the Stark case was decided. And again, quote, "A district court must take the award as it finds it and either vacate the entire award using Section 10 or modify the award using Section 11." Quoting the language from Legion again, but without the qualifier. Now, I would suggest, now there have been courts, district courts in the 8th Circuit who have gone both ways on this, but I submit that based upon that line of cases and those pronouncements, it appears to be a bright line rule. That's the way I read it. And I think support for that can be found in the Marquez case. This is Marquez Yachts versus Allied Marine Group, which was a district court decision in Minnesota, decided March 31, 2010. 2010 Westlaw 1380137. Now, in that case, a party was seeking to vacate an arbitration award, and the district court there quoted Stark and then had a discussion where it recognized that the arbitrator exceeded his powers. Now, this is rather an illuminating statement. This is what the court stated. Because the arbitration panel exceeded its powers under Section 10 in deciding Allied's claims against Marquis, but acted within its powers in deciding Marquis's claims against Allied, the court must consider two options: vacating the entire award or modifying the award. The court is not authorized to modify the arbitration award because there is no evidence that the panel's decisions on Allied's claims against Marquis affected the merits of the panel's decision on Marquis's claims against Allied. The court declines to vacate the entire award because the panel was acting in part within its powers by continuing the arbitration proceedings and issuing the final award on Marquis's claims against the defendant. So, that case, court never mentions again the indivisible test, and I submit likely because it's indicating that such a test has been superseded by the Stark's language that it's an all or nothing proposition. So, in any event, there has been no court that has ever vacated part of an award on the basis that the part in question was not reasoned. That has never happened. And I would submit to the court that it would be unjust to upset the balance of an arbitration award by vacating a portion of the award, not because the panel lacked jurisdiction or reached an incorrect result or some other violation under Section 10, but because it did not provide enough written reasons to support that portion of the award. From a policy perspective, court should not vacate only a portion of an award for a lack of reasoning. And I submit that under the law we've cited, this case doesn't fit within that anyway. It was a reasoned award. I'm ready to move on to the next issue as to the Steve Johnson issue.
Please.
As counsel has indicated, part of the basis for not affirming the award is the argument about the prejudgment interest. We've dealt with that. I submit that the sole additional basis is the alleged false affidavit of Steve Johnson. Again, it's not part of a formal motion to vacate. It's not an affirmative motion before the court. It's a resistance to our motion to confirm the entire award. Counsel submits that if the court had known about this affidavit, whether it's false, that it would have reached a different decision in compelling the arbitration. Now, I don't know whether the court would have done that or not. The court is going to have to answer that question. But based upon the reasoning in the court's decision, I submit that it wouldn't matter to the court whether he represented Moroni Feed or not, and this is why. The test about whether to apply the doctrine of contra proferentum is not who drafted that provision. The court correctly cited the test, which is you have parties of equal bargaining power, you have West Liberty represented by sophisticated legal counsel, and you have West Liberty suggesting changes to the document which are incorporated. That is absolutely clear in the record, and when you have that situation, I submit the doctrine doesn't apply based upon the cases that the court itself cited. So whether the court certainly cited this, but whether Steve Johnson was representing Moroni Feed at the time, and I will address whether I think or whether he was or not, I think the record is certainly unclear on that. It shouldn't matter based upon the test of when you apply this construction.
I look forward to your comments about whether or not I was misled.
Okay. As to the second point of that, I think the court also concluded, if I can find it quickly, that the presumption in favor of arbitration was to be applied to resolve ambiguity in the marketing agreement instead of other principles of contract construction, which I assume would mean the doctrine of contra proferentum. And the court recognized there had to be a clear intent not to arbitrate. And the court found, for 3 reasons, that there was ambiguity in Section 20. And it concluded that where there is a finding of ambiguity, arbitration is compelled. That it would be illogical to find that the agreement was ambiguous and at the same time conclude that there was clear intent. So again, regardless of that issue, I submit that the court would have reached this conclusion. But again, I don't want to speak for the court. Again, the order that is existing there is the law of the case. It has not been formally challenged. There's not been a motion to reconsider. Counsel states he is not moving under Rule 60. Of course he cannot, because it would be untimely. That's a jurisdictional bar of fraud under 60B3 that has to be made within a year, regardless of when it's discovered. We're now almost 3 years after that it was raised. So that leaves us with the issue of whether or not there was a fraud on the court. Now, we have cited the court to the applicable language. And I cite the court to Superior Seafoods versus Tyson Foods, 8th Circuit, 2010.
Is that cited in your brief?
In the brief? Yes.
Okay,
It's in our briefing. 620 F. 3rd, 873. Setting aside an order for fraud on the court is only available where it would be manifestly unconscionable to allow the judgment to stand. In United States versus Smiley, another case we cite from the 8th Circuit, the standard for establishing a fraud on the court, quote, is higher and distinct from the more general standard for fraud under Rule 60B3. Indeed, quote, a finding of fraud on the court is justified only by the most egregious misconduct directed to the court itself, such as bribery of a judge or jury, fabrication of evidence by counsel, and it must be supported by clear, unequivocal, and convincing evidence. Your Honor, those last 2 points cannot be met here. I submit to the court that I had no knowledge as to whether this was a false affidavit when I submitted it. I never would have submitted it if I had that question in my mind. The first instance that I had any indication from any source that that affidavit may have been false was during the deposition of Steve Johnson 3 years later. How can there be clear, unequivocal, and convincing evidence that counsel manufactured evidence or that there was a fraud on the court where an allegation is never even asserted in West Liberty's arguments that counsel or Moroni Feed knew the falsity of the statement? That standard is not met here. And as a result, since there is no fraud on the court should not sua sponte change its decision. I also submit, Your Honor, that West Liberty Foods...
Well, wait a minute. Does it have to be your participation in a fraud on the court? Or can it be a fraud on the court based upon the fact that a witness, a licensed attorney, made a false statement in an affidavit that was used to influence the court?
The court, I think it does in this sense, Your Honor, that courts, and I cited this in my brief, there's a difference between a party using or relying upon perjured testimony, for example, which this may be, and a party knowingly relying upon perjured testimony. There's no evidence that the party or myself, and the reason I said by counsel is because that's the language the court has used in illustrating what is a fraud on the court.
But Moroni is the party,
Yes.
and this is an attorney for Moroni,
Well,
it appears.
we don't know whether he is or not, Your Honor, because if you look at his deposition, he was asked this repeatedly through his deposition. He was asked, did you represent Moroni Feed? He said no. He said, I did not form an attorney-client privilege. That's his first statement.
Do I have in the record, and I just don't recall as I sit here, do I have in the record all of the references in the deposition to this subject matter?
You have his entire deposition, Your Honor.
Okay.
Yes. So this is kind of the genesis of it. He said he did not form an attorney-client privilege. That was his first statement. Let me turn to that. This is on page 33, lines 6 through 10. Did you ever establish an attorney-client relationship with Moroni Feed relative to these transactional contracts? Answer, no, but I did with Dave Bailey, who was the chairman of the board of Norbest. Now, Dave Bailey was the president of Moroni Feed and the chairman of the board of Norbest. Now, he later makes it clear in his deposition that, and this is page 99, verses 7 to 13. Well, my question really was pretty simple, which is, who was Mr. Bailey representing relative to the marketing agreement? The answer by Steve Johnson, when he was talking to me, he was representing Norbest. All right. So you have, then later he does say that then he's asked again, well, did you ever form a relationship? And he says, I think so. Page 33, lines 15 to 18. And then he's asked on the next page, when did that attorney-client relationship between you and Moroni Feed continue until the mid part of 2006? At least it relates to the transactional documents. Okay, that was a complete departure from his earlier testimony and from what was in his affidavit. Now, counsel wants to make hay of the fact that I objected on the basis and instructed him not to answer his attorney-client privilege. I am, shall we say, surprised. When this statement is made and he says, and Mr. Tank asks him, well, and I instruct him not to answer, he says, what's the attorney-client privilege? And Mr. Johnson responds, Moroni, Norbest, Nebraska turkey growers. Well, if this individual's asserting that's who his relationship is with, then of course I have to agree with that and say, if that's what he's saying he's representing, then I instruct him not to answer. But I knew at a minimum he was talking to David Bailey, who was the chairman of the board of Norbest. And he later clarified that when he talked to David Bailey, that was the capacity in which he was talking to him about these documents. So when he is confronted with the affidavit, he backtracks and he says, well, I indirectly represent him, which is one of the things he said earlier. And I confess it is a mishmash. But he says, I was asked at a meeting with the Board of Nebraska Turkey Growers with Ed Garrett present, and the discussion was, we want the same agreements that Norbest has. Steve Johnson prepared those. Let's have him do the initial draft. And Ed Garrett agreed to that, and so he did the initial draft, and then there was the back and forth. Now, he later tried to explain this distinction between directly represented and indirectly represented. And what he essentially says, if you look through his affidavit, he was supposed to take the lead on drafting the various documents. He drafted a letter of intent. That was for Norbest, signed it, West Liberty Foods signed it, Moroni Feed signed it, Nebraska Turkey Growers signed it. He drafted a license agreement for Norbest and Western Sales. He drafted an odds and ends agreement between Norbest and Western Sales, and he did the initial drafts of the marketing agreement between Moroni Feed and Western Sales and Nebraska and Western Sales. So why would he do that? How was he representing Norbest in that? This was his explanation. All of these agreements were necessary to transfer the duties and liabilities of Norbest to West Liberty Foods. They had an interest in making sure that Norbest was no longer liable under these agreements, and they properly transferred. Norbest, Your Honor, owned very valuable trademarks to the Norbest name. Mr. Johnson wanted to make sure that those trademarks would be protected and were validly transferred. That was the interest I submit he was trying to accomplish. Now, Your Honor, he's talking about events when he's deposed that took place 7 years before, 3 years after his affidavit. Are there statements that are inconsistent with his affidavit? No question. Are there statements that are consistent with his affidavit? No question. I don't know who he was representing. From my client's standpoint, Moroni Feed, I will submit, Your Honor, that they thought he was representing Norbest. There is nothing in the record that indicates that Moroni Feed Company knew this was a false affidavit when it was filed. And I certainly did not know it's false, and I can't say today whether it was false. It is certainly inconsistent. But was it a fraudulent false document? I don't think that conclusion can be reached made upon the record. Now,
Where is Mr. Johnson licensed?
in Utah.
Thank you.
West Liberty Foods, Your Honor, also seeks to vacate this award. It cites Section 10A1, where an arbitration award is procured by corruption, fraud, or undue means. West Liberty Foods raised this argument in its notice of fraud. It's not in its resistance, I don't believe. And the standard is, citing the Delta Mine Holding Company, which we cite in our reply memorandum, an 8th Circuit 2001 decision, a party must demonstrate that the conduct influenced the outcome of the arbitration. That certainly does not apply here. And the reason it doesn't apply is because the panel was fully informed about this false affidavit, if you will. Mr. Tank made repeated arguments about it. At the outset, before we even did opening statements, at the conclusion of the case, he dealt with it. It was fully briefed. The panel was fully aware of it. The panel was shown my objections. They're videotaped. Judge Crawford said that I did exactly what I should have done in that situation. I objected on the basis that were presented to me. So it was unquestionable that these conversations were with David Bailey as chairman of Norbest, according to Mr. Johnson. Mr. Tank asked that there be a spoliation ruling. And the panel looked at it and they said, how can we punish Moroni Feed for the misconduct of Steve Johnson? He asked for an adverse inference as to what his knowledge was. And he argued at length that what Steve Johnson would have said if, in fact, I had not objected on the basis of attorney-client privilege, and most of these were conversations directly with Norbest, John Hall and Ron Atterbury officers, that an adverse inference should come from that. and the knowledge of Norbest should be imputed to Moroni Feed Company. Even though they are two separate organizations, two separate corporate entities, even though Steve Johnson was hired as the general counsel of Norbest, was paid by Norbest for any work he did. Your Honor, I want to, now that this case was fully litigated, I think I can clarify what may have been confusing in the last time we appeared in front of the court. The court was asking, well, how much did Moroni Feed own? And it is an equity in sense, but there's two issues: equity and control. And the facts of the arbitration established that the revenues generated by Norbest went back to its two members based upon the percentage of their production. And Moroni Feed typically had 65% of the production. But as far as control, both members had one vote on the board. Moroni Feed did not have control over Norbest. So, in any event, the panel was fully informed about this, and it took no action against Moroni Feed. It expressly found that whatever Steve Johnson knew was not imputed to Moroni Feed Company. Those are issues on the merits that the panel properly was presented to them, and they decided them, and they should not be before this court. Your Honor, does the court have any other questions for me on this point?
No, I don't think so at this point.
Thank you, Your Honor. That's all I have at this point.
All right. Response, Mr. Tank?
Thank you, Your Honor. Let me start where we ended here. On the false affidavit, apparently there's still some uncertainty in Mr. Preston's mind as to who Mr. Johnson represented, and that from a, you know, there was an effort to take advantage of Mr. Johnson's role and to describe it in a way that was misleading or false. And so, you know, to now say that there's ambiguity there was no ambiguity when it was presented to you. I guess that's the point. Did I raise a fuss with the panel about Mr. Johnson? You bet I did. Of course I did. Mr. Johnson was deposed. I showed him his affidavit. He didn't have much of a response. I was given a errata sheet 2 or 3 days before the hearing was scheduled to start, where he then changed it back. He changed all his answers where he said he did represent Moroni to did not represent Moroni. And I told the panel that I can't deal with this. This is not fair. And they struck the errata based on that. Now, did they take any action relative to the decision that you made? Were they presented with an argument that his false affidavit affects the ruling on the motion to compel arbitration? Well, that wasn't before them. That's your call, Judge. That's something that you need to deal with. The panel had no issue in front of it on that, and had no right to speak about it. This is not some rogue witness off the street. A lot of times in cases we have to deal with witnesses who we don't really, we can't really vouch for overall, but we have to present their testimony. That happens. And we present it the best we can. Why would we blame Moroni and Mr. Preston for this rogue witness? It's because he was the lawyer for the defendant. That is what we're asking the court to consider. This was the lawyer representing Moroni Feed Company. His statement is attributable to his client, and we've cited cases in support of that. As far as, you know, it was a perfectly appropriate thing to do to invoke the privilege, I disagree. If you have a confounding statement in the record about who you represent, inconsistent with a prior unequivocal statement, I suggest that the proper course would have been to take a break and take Mr. Johnson into a private room and say, well, now hold it. You said, and I represented to the district court in Iowa that you didn't represent Maroney. You just said that you did. What's the truth of the matter? And then you go back in and you try to fix it or you try to clarify it, but you certainly don't assert a privilege based on just sort of a random statement in a deposition. So I'm not especially, I don't really endorse that, and I don't necessarily, want to impute to Mr. Preston an intent to deceive you. I don't know about that. I can't speak to that. I just know what he gave you and what he gave you under oath and what you considered. You're not going to base your rulings on what Mr. Preston says or what I say. You base your rulings on the evidence. The evidence in front of you was misleading. So enough of that. Let me talk about the reasoned award issue. Yeah, clearly, Your Honor, if you decide that the requirement for a reasoned award is not, has no meaning and that nothing can be reasoned, then you have to certify this award. And I guess I should have started with that. I mean, I think Mr. Preston cites a case, Arch, something from the 11th Circuit perhaps, that says we're not really too inclined to criticize a panel if they don't put reasons in there, even if they have the obligation to do a reasoned award. If that's your conclusion and the reasoned award requirement doesn't impose any affirmative duty on them, then you have to certify. If you find that it does impose a duty, then you have to look at the award.
Then I'd need to know what that duty is.
I'm sorry?
But then I'd need to know what that duty is. And it seems that that's a little hard to define under the law.
The duty of what
The duty of a reasoned decision.
Yeah, I think it is.
What does it entail?
It's very...
What must it entail? It seems to me is pretty vague in the law.
Yeah, I think it is. And that's why we cite to you some cases on that, and they talk about less than full, robust findings and conclusions, but more than nothing, all right? One of the cases that we provided the court talks about, they actually got out a dictionary and looked about reason and sort of imposed on the reasoned award standard the definition of what is reason. And it meant to that court, I think, that it's backed up by something, that there's something there that you could look at and say, well, that's why they did it. That's why they did it. And, I'm not a big... Rhetorical questions can be not very convincing, not very persuasive, and I'm not sure if I'm a big advocate of posing rhetorical questions. But in this case, maybe there's an exception to the rule, which is, if there was a reason in this award that would support the award of prejudgment interest, where is it? Point to actual language, actual verbiage, a sentence, something in that award that you say, well, there's where it is. It's right here. And the only thing we get on that sort of not very hard question is that the award at the conclusion, when they announce the result, it says, based on contracting law, we do this. Well, we know that contracting law and the law of prejudgment interest are not the same. Mr. Preston acknowledges that the dichotomy I tried to accuse him of presenting you was false. It's not contract tort. That's not the standard. It's whether, and I finally found it, Judge, and I'm sorry, whether the claim loss was fixed and could be calculated with mathematical accuracy as of a specific definite time, fixed as of a definite time. I can't tell you what that means. But I can tell you that the panel didn't appear to assess it. And because there's nothing in their award that would reflect that they did. And, this thing about, well, it's math. It's math. Of course it's math. Numbers are math. The question isn't whether there was a mathematical analysis. There was. That's not the standard. It's whether it was sufficient to meet the higher standard for prejudgment interest. And on the issue, it was very informative as Mr. Preston reviewed these cases when he said, was some judgment exercised in reaching these damages? Of course. Well, that's precisely the point, Your Honor. That is the difference in Utah between a case that allows for prejudgment interest and a case that doesn't. Shoreline Development, Utah County, quote, when a fact finder, quote, must determine the loss by using its best judgment as to valuation rather than fixed standards of valuation, prejudgment interest is inappropriate. That's the test. Best judgment. If the fact finder has to say, okay, this is not just an equation, but it requires some judgment, that is a case where prejudgment interest should not be awarded. Mr. Preston makes an argument as to why it would have been appropriate had it been considered and ruled on. And he's entitled to do that and did that to the panel. You know, I don't know what that means. I could argue to the court, Judge, here's what happened. We provided the panel mountains of evidence, depositions, hundreds of exhibits, and they had the time for their reasoned award extended once, and this actual award that came down hit my email inbox on the day before it was due. And so I think based on that they struggled with the liability issue quite mightily, figured out right at the end that, oh my gosh, we have to enter an award on interest, and didn't talk about it at all. I could make that argument. But it wouldn't be based on, it'd be an argument. It wouldn't be based on any evidence. And so just as Mr. Preston's argument that had they considered it, they would have granted it, is really of no significance, any argument that they wouldn't have granted it is likewise not persuasive. They are judged by what they did, not what they might have done, could have done, or not. As far as partial vacation, yes, you're exactly right, Your Honor. Stark versus Sandberg speaks to that. And it says, here's a quote, a district court must take the award as it finds it and either vacate the entire award using Section 10 or modify the award using Section 11. And there's a cite, that's from Legion. Legion cites to another case, I'm sorry, that's the Stark case. Forgive me. Citing to Legion. When you pull up the Legion case and read that, here's what it says. Whatever the rule may be under different circumstances, when a panel by the language it uses makes clear that it intends its award to be indivisible, and then it has the quote taken by the Stark court. The district court must take the award as it finds it. So I can't tell from reading the verbiage in Stark, which was dicta, they didn't say we would vacate it if it was proper to do it partially. They said that the panel had full authority to decide the punitive damage issue, and this issue of partial vacation was not material to their outcome. And then they went on and they said what they said, citing to Legion, which appears to impose this other standard about when a panel by the language it uses makes clear that it intends the award to be indivisible. And Mr. Preston talked about that. Well, again, it's a rhetorical question. What language in the award would reflect or could fairly be construed as reflecting the panel's conclusion that what it was doing here was indivisible? In other words, this is to be viewed as a whole, take it or leave it. They didn't say anything that would be evidence of that. I mean, if you think you need to certify or vacate it in its entirety, vacate it. Throw the whole thing out. Didn't meet the standard for reasoned award, throw it all out. Vacate the entire award, if that's what you feel compelled to do. Whether you can partially vacate or not is not outcome determinative. It just means you've got to make an election. And your election can be to vacate it in its entirety if that's what you think is appropriate. So we've been here a long time. I appreciate the court's attention. The lawyers have been working on this case many months, many years, and we finally are to the point where we're close to a resolution. And I appreciate your attention today, Judge.
All right, thank you, Counsel. Mr. Preston, your final remarks, please.
Thank you, Your Honor. So again, what language makes it a reasoned award? I think that phrase at the beginning of the conclusion, based not only on contracting law, but based on the evidence we find. The evidence included Chesley Erickson's report, which it endorsed. And then it referenced the Utah statutory rate. So you can, if you can infer it, which counsel concedes you can do, you can certainly infer that the court reached this decision and agreed with our position on this point. That is all you need. That's all that was needed in Cat Charter. And some of these other cases had similar summary sorts of statements. Again, you just need to have a mention of an explanation. Is there no explanation? No, there's an explanation. There's an explanation that was based on the evidence and contract law. These awards are being made to Moroni Feed Company, and these awards are being made to West Liberty Foods. The fact that West Liberty Foods says its award of prejudgment interest is reasoned, it's no more reasoned than Moroni Feeds. I think it's less reasoned because it talks about the statutory rate and it talks about you have this endorsement of Mr. Erickson's calculations. Your Honor, the fact that you exercise some judgment doesn't mean it's suddenly thrown out. That is what ENCON said. The court, as I read to you, the court was saying, yes, the court had to exercise some judgment as to which expert, but this was something that was based on facts and figures. It was subject to mathematical accuracy, and it upheld it. What it's talking about is best judgment. Your best judgment is, in a wrongful death case. You can talk about what they might have earned or this or that, but there is no fixed sort of methodology. This is a methodology, a clear methodology, where you can calculate to the penny what the accrual funds are. And again, it would be, I think, ironic if Moroni Feed was penalized and not allowed prejudgment interest when what Mr. Erickson was doing was reducing the damages, exercising his judgment to have a conservative award. And again, it wasn't like he was pulling this out of air. He was looking at the accounting records of West Liberty Foods and how they categorized the expenditures and whether they fit within the language of the agreement as to what could be offsets. Which again, the court specifically mentioned in affirming his damage methodology. I submit under these cases, when you look at this as a whole, and the fact that no court has ever done this, said, okay, because this specific issue was not reasoned, and what is the only case that's done it in general was Vold, where there was no explanation whatsoever. It was simply an announcement. This was more than an announcement. It was reasoned under the case law that is before the court. It's not like the Steve Johnson affidavit where his role was presented to the court in a vacuum. At the end of the discussion, it was brought up, the joint ventures between the parties. What role, what ownership interest did Moroni Feed have? And it was, we stated, greater than 50%. And again, it's really an equity as far as revenues that was 65%. But as far as control, it was 50-50. And I can clarify that now based upon what we learned during the course of the case. So everybody knew who he's actually hired by. Johnson's understanding about who he represented was affected by Mr. Tank's line of questioning. Johnson's answers changed based upon the line of questions that were asked to him.
This isn't a guy off the street. This is
No,
a
it's-
licensed attorney.
Yes,
who
and
is
by the way, he's
employed by
licensed.
large companies to draft detailed documents for them. So you're suggesting to me that Mr. Tank was able to mislead him in a deposition to these answers?
No, but I'm not saying he was misled. I'm saying he was confused, clearly.
Okay.
But again, if he did mislead, Moroni Feed did not consider him to be its attorney in this matter. Ross Blackham didn't consider him to be his attorney, Moroni Feed's attorney. The fact that Mr. Johnson said he was, David Bailey never said that he was Moroni Feed's company attorney. He said we never paid him.
Well, you don't need to go through that because I'm going to go back and take a look at the affidavit, and I'll take a look at the deposition, and I'll just have to make a determination of how significant I believe that is.
Okay. All right. Thank you, Your Honor.
All right. Thank you, counsel.
Thank you, Judge.
The matter is submitted, and we'll get something out as quickly as we can. Thank you.
Thank you for your time, Your Honor.